A warm welcome. Greetings of the day. I am D. Kumaresan, Assistant Professor in Department of Management Studies. In this video, we are going to see the subject legal aspects of business. In the previous video, we discussed about the meaning of the contract and the essential of contract. Now, in this video, we are going to see about the types of contract. The types of contract is basically segregate under four types of heads. First one is on the basis of enforceability. Under this heading, it has the subheading of valid contract, void contract, voidable contract, illegal contract, unenforceable contract. And second one is on the basis of formation. It has the subheading of express contract, implied contract, and quasi contract. And third one on the basis of performance. It has the subheading of executed contract and executory contract. Fourth one on the basis of obligation, unilateral contract and bilateral contract. Now we deeply discuss about the first point on the basis of enforceability. Under this, on the basis of enforceability, first heading was valid contract. A valid contract means an agreement is valid contract if it fulfills all the essential requirements of the contract given under the section 10. A valid contract is enforceable by law. Lack of any element prescribed under the section 10 would change the legal status of contract and it may not be permitted to be enforced. For example, X offers to marry Y and Y accepts X's offer. This is a valid contract. Next one, void contract. It is a contract without any legal effect and could not be enforced in a court of law. Section 2J says that void contract is a contract which cases to be enforceable by law, where both parties to an agreement are under a mistake of fact. Section 20, when the consideration or object of in agreement is unlawful. Section 23, an agreement made without consideration. Section 25, etc. are instructs of a valid void contract. Next, third one, void agreement. Section 2G says that an agreement not enforceable by law is void. Agreement becomes void if it lacks any one of the essential of valid contract. Void agreement is void when it is made. One of these factors is unlawfulness of object and consideration of the contract, that is, illegality of the contract which makes is void. In void agreement, if the party has suffered any loss, he could not claim any compensation. Voidable contract. Section 2I says that voidable contract is an agreement which is enforceable by law at the option of one or more parties but not at the option of the other, or other is a voidable contract. Agreement becomes voidable if the consent of one party had not been free, except mistake. Voidable contract became void only when it is declared to be so by an aggrieved party. If aggrieved party is voidable contract caused by fraud, suffered any loss, he has the right to claim compensation from other party. For example, a contract brought about as a result of coercion, undue influence, fraud or misrepresentation would be voidable at the option of the person whose consent was caused by any one of these factors. Next one, illegal contract. It is a contract which is forbidden by law. Illegal contract, if permitted, would default the provision of any law or is fraudulent. It may involve or imply injury to a person or property of other. Court regards it as an immoral, opposite to public policy. The court will not only enforce such a contract but also other contract. All illegal agreements void, but all void agreements or contract are not necessarily illegal. Every agreement of which the object and consideration is unlawful is not only void as between immediate parties but also taints that collateral transaction with illegally. In Bombay, the wagering agreement have been declared unlawful by statute. Sixth one, unenforceable contract. Where a contract is good, is substance, but because of some technical default, it cannot be enforceable by law. It is called as a unenforceable contract. These contracts are neither void nor voidable. Such contracts are good in substance, but due to non-fulfillment of prescribed legal formalities, these cannot be claimed in the court. As soon as the technical reason is looked into, redactful that such contract may be allowed to be enforced. Thank you very much. In this video, we discuss about the types of contract. Types of contract has four types on the basis of enforceability, on the basis of formation, and on the basis of performance, and on the basis of obligation. We discuss about the on the basis of enforceability. In the next video, we will discuss about on the basis of formation, on the basis of performance, on the basis of obligation. Thank you for watching. Thank you very much.